Let's pray. Guide, we beseech thee, Almighty God, members of this honorable house, that they may wisely deliberate for the good of this country and for the glory of thy holy name. Join me in saying the Lord's Prayer, please. O Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. Lead us not into temptation, but deliver us from all evil. For thine is the kingdom, the power, and the glory, forever and ever. Amen. You may be seated. Good morning, everyone. This parliament is now open.
Item 3, oath of allegiance or affirmation of a new member. Item 4, confirmation of minutes.
Leader of government business.
Thank you, Mr. Speaker. Good morning to this honorable House. Mr. Speaker, I beg to move that the minutes of the proceedings of a sitting of the House of Representatives held at Parliament Chamber, Mount Well, St. George's, on Tuesday, the 17th of February, 2026, at 9 a.m., be taken as read.
Honourable members, the question is that the minutes of the proceedings of a sitting of the House of Representatives held at Parliament Chamber, Mount Well, St. George's, on Tuesday, February 17, 2026, at 9 a.m., be taken as read. Those in favor say aye. Those opposed say no. Minutes taken as read. Leader of government business.
Thank you, Mr. Speaker. I beg to move the minutes of a proceedings of sitting of the House of Representatives held at Parliament Chamber, Mount Well, St. George's, on Tuesday, the 17th of February, 2026, be confirmed.
Honourable members, the question is that the minutes of the proceedings of a sitting of the House of Representatives held at Parliament Chamber, Mount Well, St. George's, on Tuesday, February 17, 2026, at 9 a.m. be confirmed. All those in favor say aye. Aye. Those opposed say no. Minutes confirmed.
Messages from the Governor General. Item 6, announcements by Mr. Speaker.
Honourable members, I am advised that for this sitting we would not have the President of the MP for St. Andrew Southwest, as he is out of state on state business. I wish to announce in this House as well that Grenada was represented at the Parliament of the Americas General Meeting in Washington by the Honorable President of the Senate, Decima Williams, and that yours truly will be attending the Palatino Conference of Speakers in Panama from 26 to the 28th of March this year. Immediately following this sitting today, all MPs are invited to watch a presentation on the Polaris project, of which I think we all should be acquainted. And today, the world celebrates World Tuberculosis Day, as well as International Day for the Rights to the Truth concerning human rights violation and abuse of persons. Those are my announcements.
Item 7, presentation of petitions. Item 8, presentation of papers and reports from select committees.
Leader of Government Business.
Thank you, Mr. Speaker. Mr. Speaker, I wish to lay the following papers and reports before this Honorable House. Firstly, Mr. Speaker, the annual report of the Marketing and National Reporting Board financial statement for the year ended 31st December 2021. Secondly, Mr. Speaker, Fiscal Resilience Oversight Committee, FROC, 2025 annual report. And finally, Mr. Speaker, the Fiscal Resilience Oversight Committee 2025 annual report at a glance. Thank you, Mr. Speaker.
Thank you, Leader of Government Business. These documents are now laid.
Item 9, unopposed private business. Item 10, questions. Item 11, urgent questions under the provisions of Standing Order No. 21. Item 12, statements by ministers.
All right, MP for Leader of Government Business. The first person on the floor would be MP for St. Andrew Northwest.
Thank you, Mr. Speaker. Mr. Speaker, I rise to provide ministerial update on a successful hosting of this year's Intercall Games, an event that once again showcased the depth of talent, discipline, and sporting excellence among our young people. At the onset, I wish to place on record special recognition to the Principal Association, whose leadership and coordination was central to the successful execution of this year's games. This year, truly a Principals Association production, and their commitment to organization and collaboration ensured a well-run and high-quality event. Mr. Speaker, I also take this opportunity to commend the National Lottery Authority, the main sponsor of Intercall 2026, for its significant contribution of $350,000, which was approved by the government. This investment underscores the continued commitment to youth development and the advancement of sports in Grenada. I further commend all participants, participating schools, for their preparation, sportsmanship, and the high standard of competition displayed throughout the games. Each institution continued to make this a true national celebration. Special mention must be made of the St. Andrew Anglican Secondary School, SAS, for the outstanding double victory in both the male and female division. This is more than triumph for the school, but a proud moment for the entire parish of St. Andrew. A true parish victory reflecting unity, pride, and collective effort. At the same time, Mr. Speaker, we recognize the superior performances of other institutions including the Grenada Boys Secondary School, St. David's Secondary School, Anglican High School, and St. Joseph Convent, along with the many outstanding athletes across the island who elevated the level of competition. Mr. Speaker, these results are not accidental. They are the direct outcome of deliberate and sustained government investment in youth and sports through infrastructure, programs, and athlete support system. We are now seeing the tangible results of those investments on the track and on the field. We remain committed to strengthening this effort to ensure that every young person is given the opportunity to develop, compete, and excel. I commend all who contributed to making this event a worthwhile activity. Mr. Speaker, I also want to congratulate our Spice Girl, Afi Fletcher, on reaching the incredible milestone, 100 T20 International Week last weekend. The achievement is a testament to her skill, consistency, discipline, and unwavering commitment to sports. It places her among an elite group of cricketers and highlights her enduring contribution to West Indies cricket. Mr. Speaker, Afi continues to make Grenada and the wider Caribbean proud. Her journey serves as an inspiration to many young athletes, especially our young women, demonstrating what we can achieve through hard work and determination. Mr. Speaker, just recently on her home soil, Afi also attained her 100 T20 matches. And as a government, we provided incentive of 100,000 East dollars to her. Mr. Speaker, on another note, Grenada stands ready to welcome the Caribbean as we prepare to host the prestigious regional event, the Carifta Games, which represent one of the most important platforms for youth athletics development in our region. And it's both an honor and a responsibility for us to serve as hosts. Preparation are well advanced and key stakeholders working collaboratively to ensure that all facilities, logistics, and operational systems meet the required standards. Significant attention has been given to the readiness of our sporting infrastructure, accommodation, and transportation, and the overall athletic and spectacular experience. Mr. Speaker, hosting Carifta is not only about sports. It is an opportunity to showcase Grenada's capacity to deliver world-class events while also stimulating economic activity and national pride. It allows us to highlight our culture, our hospitality, and the strength of our young people on a regional stage. We also anticipate strong participation from our national team, and we are confident that our athletes would rise to the occasion and represent Grenada with distinction, especially after what we saw in Intercall 2026. Mr. Speaker, this event is yet another example of deliberate government investment in youth and sports, positioning Grenada as a hub for athletic excellence in the Caribbean. I take this opportunity to thank our partners, volunteers, organizing committee who continue to work tirelessly to ensure the success of Carifta 2026. We look forward to welcoming the region and delivering a memorable and successful games. We invite everyone in Grenada, Carriacou, and PD Martinique to be a part of this very important initiative. I thank you.
Thank you very much, Honorable MP for St. Andrew Northwest. And I invite the Head of Government Business to take the floor.
Thank you, Mr. Speaker. Mr. Speaker, I just want to provide some updates from the Ministry of Health. And so, Mr. Speaker, we continue to work within ministry to ensure that we improve the quality of care island-wide, as a matter of fact, statewide, meaning Grenada, Carriacou, Ampiti Martinique. I just ended a visit to Carriacou and Petit Martinique yesterday, Mr. Speaker, just to get a first-hand view as to what has been happening there with the completion of the upgrades of the facilities. And we are happy to report, Mr. Speaker, that all of the facilities on the island of Carriacou has been complete to the level of 99.9%. So we are barely there. On Carriacou also, Mr. Speaker, we are the proud recipient of laboratory outfit and clinic from Southcom, and we are in negotiations with them, Mr. Speaker, with the view of having the laboratory outfit or facility be relocated to the Princess Royal Hospital, because we believe, Mr. Speaker, the impact will be greater. It will be greater felt on that island, and the utility will be much better. And so, Mr. Speaker, we continue our dialogue with the view of being able to relocate that particular facility and bring, for the first time in history of Carriacou and Petit Martinique, bring laboratory equipment and services to those beautiful islands. Mr. Speaker, I'm proud also to report the receipt of laparoscopic equipment and training from one Dr. Ducoin and family, who has seen it fit to assist us in that area as we continue, Mr. Speaker, to lobby strong with our partners in collaboration with the St. George's University and the South Florida University. Mr. Speaker, or University of South Florida proper. Mr. Speaker, this equipment is innovative because, to break it down, it allows the physician or the surgeon to be able to enter into the internal organs by way of only the equipment and the camera to be able to see what is going on and perform the surgery without cutting a big gap into the body. And Mr. Speaker, this is innovative for us. We have started that process some time ago with the assistance of Dr. McKinney, who has been doing so for most of the female or gynecology surgery. And so that has been happening, and the training continues with that also. So we are moving forward, Mr. Speaker. So laparoscopic surgery is also referred to as what we call keyhole surgery, in which you make a little incision into the body to perform major surgeries. And that is very innovative for us. So we continue to work in that area. Mr. Speaker, what does that do? This helps us in one, the patient will be able to heal much faster and be able to restore their health much faster. Additionally, ward time, bed nights on ward, will be significantly reduced. And so, Mr. Speaker, these are very important, both for the patient as well as for the hospital management, because every night spent at the hospital requires output of staff, cleaning, laundry, medication, doctor and physician time, as the case may be. So it's meals and everything else that goes along with it. So there's a lot involved in the process, and so whatever we can do to minimize it and to create more space for incoming patients would certainly be a plus for us. And of course, it's faster than the open surgery. Mr. Speaker, mammogram equipment with biopsy capabilities has also been installed at the hospital. And that again is innovative and a first for us as we continue to improve services. So, Mr. Speaker, gradually we are making some significant headways, and things are happening, things are changing on the ground as far as healthcare is concerned. In collaboration with the Mount Sinai International, Mr. Speaker, we continue to work on the 13 thematic areas to transform service at the hospital. And in particular, Mr. Speaker, the emergency department. We have done a lot of work there. We have done the gap analysis. And Mr. Speaker, we're just doing the mapping to finalize, to determine how we're going to tweak the service to make it much faster, to create faster turnover for patients as they come into the hospital. And so, Mr. Speaker, we continue to work with our team to ensure that that happens. As part of the whole change management exercise in collaboration with Mount Sinai and Project Polaris, Mr. Speaker, we will be hiring in some key personnel to assist and to lead the change management. So we'll be hiring in change managers. And one would understand, Mr. Speaker, that it is necessary to hire in international experts with great change management skills to lead this process. And so we will be, Mr. Speaker, in due course, hiring a CEO, a Director of Quality Improvements, Director of Human Resources, Chief Engineer, and a Chief Financial Officer or Financial Controller. And these are critical hires, Mr. Speaker, because these are areas that is really going to lead the transformation in terms of the change management. We have wonderful clinicians, doctors and support staff and what have you, but Mr. Speaker, in terms of the governance and the change in terms of the leadership, it is critical that we fill these gaps as we continue towards the statutorization. And Mr. Speaker, speaking of that, following this sitting this morning, we will be having the statutorization transition team do a presentation here at the Parliament to involve the opposition and the upper house in that consultation, so that everyone would be brought up to speed as to what is happening as far as the statutorization is concerned. Mr. Speaker, we are going through every single parish, including our Sister Isles, to speak about statutorization, to hear from our people, to receive input into the framing of the policy and the subsequent legislation. And we consider this to be extremely important, Mr. Speaker. We did receive help from the Tony Blair Institute with the drafting of the policy and other local experts, of course. And so, Mr. Speaker, that has helped us immensely in terms of laying the foundation for what policy looks like. But going forward, Mr. Speaker, the input of the general population, they that receive the service at the operational level, it is important to hear from the general public and to include the contribution into the framing of the policy and the legislation. So we look forward and we encourage everyone, Mr. Speaker, to be part of that consultative process. Additionally, Mr. Speaker, this Friday, March 27th, 4 p.m., Calvini, there will be the sword turning for the new hospital. Project Polaris will be leading that, Mr. Speaker, and we welcome all and sundry to be part of it. We expect all of Grenada to come and be part of the process. Mr. Speaker, this is transformative. This is the first time since the construction of, I would say, the international airport and SGU. This is the third largest investment on the state, within the state of Grenada. This is absolutely transformative, and we need all of Grenada to take a stake in their hospital, to take a stake in their own health care. And so, Mr. Speaker, this is only some of the heavy lifting that is happening right now at the hospital, at the Ministry of Health. Added to that, Mr. Speaker, I wouldn't go into it, but I'll just say that we continue the process of upgrading all of the health facilities around the country, right? So there is going to be some inconvenience with service. Some of the services may have to be split up a bit into different areas to accommodate the renovations. And as we speak, Mr. Speaker, contracts are being signed. Works are happening in St. Patrick's, St. David's. We are in the process of getting the contractor uploaded. The same happened for Granba and a lot of other areas, Mr. Speaker. And just to mention quickly, as I close on this, to say that Mount Rich is complete. Mount Rich is complete. And finally, Mr. Speaker, in terms of what I wish to bring to the attention, in terms of my ministerial statement, I have been asked to update this Honorable House on behalf of Mr. Lennox Andrews that Grenada restores access to the U.S. market after the National Marine Fisheries Services granted fisheries comparability findings. And Mr. Speaker, that is very important because there was quite a lot of noises, but the government of Grenada worked assiduously, and we commend the public servants, we commend the Ministry of Agriculture, led by the Permanent Secretary, working on weekends, working around the clock to ensure that the comparability findings meet the requirement of the National Marine Services. Mr. Speaker, the government of Grenada welcomes the decision by the United States National Marine Fisheries Services confirming that Grenada fisheries management measures are comparable in effectiveness to those required under the Marine Mammal Protection Act for designated commercial fisheries, resulting in the restoration of access to the United States market. So again, Mr. Speaker, we offer our appreciation to the organization for the comparability findings for Grenada, and our appreciation goes also to the Ministry of Agriculture. Thank you, Mr. Speaker.
Thank you very much, Leader of Government Business.
Item 13, personal explanation. Item 14.
Oh, Honorable MP for St. George, Northwest.
Yeah, Mr. Speaker, I just stand briefly to make 2 points on this your personal explanation. I just once again to just remind the Honorable House of the decision that was taken at the beginning of the St. Parliament term, that discussions, at least information on both sides of the House, when a Parliament session is to be called, there must be some contact or information on the other side. Not a notice just saying Parliament is so-and-so date and Parliament is this date. This is so basic, Mr. Speaker, that having been around in this House for so long, in opposition and in government, this has been the practice, the fundamental practice, just a simple communication about the dates so that at least we're on the same wavelength, so to speak. For what it's worth, I'll keep repeating that every time so it goes into the Hansard about the problem that we have with a basic fundamental principle that has been observed by almost every house that you have been part of. Mr. Speaker, also, as a member for Parliament for St. George's Northwest, I'm extremely concerned that the problems that the Perseverance area is a major health hazard for the people of Bazan and close community, because this smoke that is constantly out there affects people. The Concord area, the people from the St. John's will have to be concerned also, because you're talking about smoke that comes from carcinogenic materials. We may not see the effects of that today, and some of us may not even be around when the effects are evolving. But it seems to me that it's something that should be concerned. And what is in fact more disconcerting is the fact that, as far as we understand, was started by the burning of some materials from a certain ministries of government. If that is the case, then in fact government could be accused of participating in the health destruction of the people of certain parts of the country. And you don't know, Mr. Speaker, we're talking about just one section of an area, but this smoke goes far. So people not necessarily in the vicinity can also be affected. In other words, those of us that drive past there on a regular basis. I left my home this morning and went up to Perseverance to see, because one day I passed and then there were hardly any smoke. So I passed it this morning, a massive level of smoke in that area. So the bus drivers and the vehicle owners who drive, they have to be also be very concerned. So I raise it again for those involved who understand the seriousness of this and have a responsibility to protect the nation and the people, and particularly as a member of St. Andrew Southeast, who is also leader of government business, who was assigned to be the one making contact with the opposition representative about this in Parliament, and also who is the Minister of Health, should also be very much concerned about what is taking place. And I suggest that he briefly, with a mask, make sure he can pass up at Perseverance, Mr. Speaker. Nice to be smiling, but it's a very serious issue to see for yourself. I don't think as Minister of Health that you want to preside over the possible destruction of health of the people of any part of the country. In fact, might be your own health that's being affected. So I make this on a personal explanation as to point of Mr. Speaker, the seriousness of this, and that the government will be taking this far more seriously than it appears to be taking at this particular time. And people say John should also be very concerned.
All right, thank you, member of St. George Northwest. I wish to make this point that when you are standing under one of the items, your comments must speak directly to the items. So personal explanation, in my view, must be of a personal nature, right? Of a personal nature. And so matters that sometimes we want to raise under personal explanation are better placed under the adjournment, right? Personal explanation must take a personal connotation. All right, so Honorable MP, you know that I didn't stop you. I allow you to proceed, and I'm telling you what I see as personal explanation.
I'm just saying that you are not correct, Mr. Speaker. With all due respect to your office and to you personally.
I just made it clear what I would accept as personal explanation going forward. Honorable MP.
You could say it, but I'm making the point.
Honorable MP, you can sit and argue with the speaker.
Mr. Speaker, I'm sorry.
All right, the light of, whose light is it? Please take the floor. Yeah? Honorable MP, please take the floor.
Mr. Speaker, you don't make this thing a controversial. This is unnecessary. That's all I can say.
Thank you, Mr. Speaker. Mr. Speaker, I rise with your guidance because I'm happy that you made note of what the personal explanation agenda item is really and truly. And being the line minister for the Grenada Solid Waste Management Authority, the standing order precisely states that for personal explanation, non-controversial matters is to not be used underneath that agenda item. But because a statement was made through you, Mr. Speaker, in the member for St. George Northwest, in terms of the authority lit a fire there, it's controversial in nature, so I'm asking through you permission to present to you the statement and overview of the report that was submitted on behalf of the authority, because we cannot have that recorded in Hansard. So I'm requesting permission. I know personal explanation cannot be used for debate, but because a controversial matter and an inaccurate response or comment was made by the minister, I would ask kindly to just briefly go through. Or we can take it under the adjournment.
Exactly what I was going to arise. I would take it under the adjournment. Let's keep it personal, yeah. So you would come in under the adjournment and make those points.
Thank you, Mrs. Speaker.
Item 14, motions. Item 15, bills.
Mr. Speaker, the Leader of Government Business, I think, took a bathroom break in the middle of the controversy. So, would you leave, Mr. Speaker? I go back to stand in unless that's him coming.
He's coming, so...
Thank you very much, Mr. Speaker.
Yeah.
Thank you.
Okay. The government business, we on item 15. Bills. Yeah.
Thank you, Mr. Speaker. Thank you, for Prime Minister, for your usual versatility. You behave as a cricketer, fit and ready to bat at any time. Speaker, some people don't know the difference between a fit match and a serious cricket match, you know. But Mr. Speaker, I beg to introduce for its first reading a bill for an act shortly entitled Possessory Title Amendment Bill 2026.
A bill which seeks to amend the Possessory Titles Act 2026, shortly entitled the Possessory Titles Amendment Bill 2026.
You have government business?
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the relevant standing order of the House be suspended to enable the bill to be taken through all the stages at this sitting.
Honorable members, the question is that the relevant standing order of the House be suspended to enable the bill to be taken through all stages at this sitting. Those in agreement, say aye.
Aye.
Those opposed, say no. The ayes have it, I think. The ayes have it. You have government business?
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the second reading of the bill.
Honorable members, the question is that the bill be read a second time. Leader of government business?
Thank you, Mr. Speaker. Mr. Speaker, Possessory Title Amendment Bill 2026 contains 21 clauses. It's a relatively long bill. And of course, Mr. Speaker, Clause 1 of the bill speaks to the short title. And Clause 2 seeks to amend Section 2 of the Principal Act to insert a definition for land surveyor to complement the amendment of Section 5 of the Principal Act. And in this context, Mr. Speaker, a land surveyor means a land surveyor who is licensed pursuant to the Land Surveyors Act, Chapter 162. Mr. Speaker, this bill is making 13 key recommendations for change to the Principal Act to bring clarity to a number of dubious areas and to offer some consistency. Mr. Speaker, the 13 key recommendations change are as follows. Firstly, to bar a person from claiming possessory title to land more than once within a 20-year period. Secondly, the bill seeks to prevent a person from receiving possessory title for more than 1/4 of an acre of land, unless the person can demonstrate the adverse possession of the portion in excess of 1/4. Mr. Speaker, following these areas, I would seek to give a little insight into some of the key aspects of change. So the third recommendation, Mr. Speaker, the third change that this bill is proposing is that it mandates that additional particulars be included in the application for declaration of possessory title and the accompanying plan. Fourthly, Mr. Speaker, it mandates that the Attorney General be named as a respondent and be duly served and file documents in the possessory title proceedings. So the Attorney General now, Mr. Speaker, will be a respondent in the matter. Mr. Speaker, fifthly, it mandates that a report from the land surveyor be included along with the application for possessory title. Sixth, it expands the responsibility of and the medium through which the Registrar of the Supreme Court could publish notices. Seven, it mandates that an applicant serve the applicant, it mandates that serve the applicant and his accompanying documents on all persons identified by the immediate owner of the land. Number eight, in terms of the key recommendations for change. This also seeks, Mr. Speaker, to improve the method of service of notice of possessory title proceedings to owners and occupiers of adjoining lands, those in boundary with. Number 9, Mr. Speaker, it seeks to remove the fixed fee that the attorney at law are permitted to charge for service provided for possessory title proceedings. So it seeks to remove that fixed fee and we want to now give a ceiling of a maximum fee. Number 10, Mr. Speaker, mandates that an applicant pay a deposit to the Registrar of the Supreme Court towards the administrative costs concerning the proceedings. So they're now obligated to pay that administrative cost, and we see what that is. Number 11, it removes the unique claim form and the form for entry of appearance under the Act, and replaces it with the form under the Eastern Caribbean Civil Proceedings Rule. Number 12, Mr. Speaker, empowers the court to set aside or vary an order granting possessory title after the allotment period has expired in exceptional circumstances. And finally, Mr. Speaker, number 13, this bill seeks to correct certain references to the Registrar of the Supreme Court with reference to the Registrar of the Deeds and Lands Registry. Mr. Speaker, with reference to these recommendations, and in particular that 20-year time frame, Mr. Speaker, Clause 3 speaks to it, and it inserts a new section, Section 3, subsection 5, to prevent a person from claiming possessory title to land more than once within the period, as earlier stated. Mr. Speaker, Section 5, or subsection 5, where a person has obtained a declaration of possessory title in accordance with this Act, the person shall not make a subsequent application under this section for any other piece or parcel of land within that 20-year period. A period of at least 20 years must therefore elapse. Mr. Speaker, with respect to the second recommendation that speaks to the limiting of the size of the plot of land to a quarter acre, Clause 4 treats to that. It amends Section 4, subsection 1A, and that seeks to prevent from receiving possessory title for more than a quarter of an acre unless the person can demonstrate the adverse possession of that portion in excess of quarter acre. So they must be able to demonstrate that they have been in possession of more than that quarter acre. And an application for the declaration of possessory title shall be made in accordance with Form 1 of Schedule 1 and shall include the following: description of the land. It shall also include the boundary limits and the estimated value. And in the case where it exceeds quarter acre, the acreage of the piece or part of land for which the adverse possession is claimed. Mr. Speaker, in respect of recommendation 3, Section 4 currently provides that an application for declaration of possessory title shall be made in accordance with Form 1 of Schedule 1 and shall include description, boundaries, and values, as earlier stated. Clause 4, Mr. Speaker. Clause 4 seeks to amend Section 4(1) and provides that an application for declaration of possessory title shall be made by a fixed date claim in accordance with the East Caribbean Supreme Court Civil Procedures Rule 2000, and shall include the following: the description, the boundaries, values, and so on, the acreage in the case of where it exceeds quarter acre. Mr. Speaker, the fourth recommendation in respect of the inclusion of the Attorney General as a respondent in the proceedings. This bill recommends and mandates, as a matter of fact, that the Attorney General be named as a respondent and serve all filed documents in the proceedings. The Office of the Attorney General would bear the responsibility to confirm whether the land is Crown land or not. Clause 4, Mr. Speaker, insert section 4.2, an application under subsection 1 shall name the Attorney General as a respondent, and clause 11 insert section A4. And section A4 states, upon filing an application for declaration of possessory title, the applicant shall cause a copy of the document filed in support of the application under section 5 to be served on the Attorney General. So, Mr. Speaker, that is covered. The Attorney General would receive under this new bill all the relevant documents and be so named as a respondent. Mr. Speaker, the other recommendation, recommendation 5, that treats with the use of a licensed surveyor, the report from a licensed surveyor. It mandates that the report of a land surveyor be accompanied or shall accompany the documents so filed, and full description of his findings shall be included in the report. Clause 6, Mr. Speaker, a plan for the purpose of this section shall include the following: the degrees, the dimensions, the bearings, and measurements of the land, of the various points on the land, the name of the owner of each adjoining lot, and any natural or artificial features that is unique to that plot of land. Recommendation 6, expansion of the responsibilities for the registrar. So section 7, Mr. Speaker, currently provides that upon filing an application for declaration of possessory title, the applicant shall publish a notice in accordance with Form 2, Schedule 1 in the Gazette, and shall also publish a notice in accordance with the same form in 2 issues of at least 2 newspapers circulating in Grenada. And also, between the dates of the first and the last publication in the newspaper, post or cause be posted a copy of the notice in a conspicuous place at the registry and in a conspicuous place in the magistrate court and in the said district, magistrate court in the district. But, Mr. Speaker, this bill seeks to repeal that section and replace it accordingly. So Clause 8 seeks to repeal and replace Section 7, which I just read. Says, upon filing an application for declaration of possessory title, the applicant shall do the following. A, publish a notice in accordance with Form 2, Schedule 1, accompanied by a copy of the plan that has been authenticated in accordance with Section 6, Subsection 1 in the Gazette. So, Mr. Speaker, this, as I mentioned earlier, is adding a little more precision to what is needed to be included and much more directness and more information so that the court can make a proper decision, a proper ruling as far as possession is concerned. B, Mr. Speaker, the applicant must publish a notice in accordance with Form 2, Schedule 1, accompanied by a copy of the plan that has been authenticated in accordance with Section 6.1 in 2 issues of at least 2 newspapers circulating in Grenada, the second issue of each newspaper being published not less than 2 months after the first issue. And C, between the dates of the first and the last publication, under paragraph B, serve on the registrar the notice in accordance with the same form, accompanied by a copy of the plan that has been authenticated in accordance with Section 6.1. Clause 8 continues, Section 2, within 14 days of receipt of the notice in accordance with subsection 1C, and the deposit under Section A, deposit which has to be made by the applicant, the registrar shall post or cause to be posted a copy of the notice in a conspicuous place at the following places. The registry, the Deeds and Land Registry, or Supreme Court Registry, Deeds and Lands Registry, the magistrate court in the district at a conspicuous location, and on the official government website. All expenses, Mr. Speaker, for posting of the publication under subsection 2 shall be charged to the applicant. Mr. Speaker, clause 9 of the bill inserts a new section, Section 7A, and this provides a requirement to serve notice to previous owners of the property. Again, that being very important. Clause 7A, subsection 1, where records at the Deeds and Lands Registry indicate the name of the owner of the piece or parcel of land immediately before the period for which the applicant claims to be in adverse possession, the applicant shall, not less than 21 days after filing the application for declaration of possession of title, cause a copy of the notice pursuant to Section 7 to be served on the owners. Personally, in accordance with Part 5 of the Eastern Caribbean Supreme Court Civil Proceedings Rule 2000, and secondly, outside of the jurisdiction in accordance with Rule 7.3 of the Eastern Caribbean Supreme Court Civil Proceedings Rules 2000. Clause 9, Mr. Speaker. Clause 9 inserts a new section, 7A, where an owner named in the records at the Deeds and Lands Registry is deceased, The applicant shall serve notice on the estate or shall serve the estate of the deceased person pursuant to paragraph A or B of subsection 1, as the case may be, sorry. And 3, an order containing a declaration of possessory title shall not be granted unless the provisions of this section are complied with, and not less than 6 weeks have lapsed after the service of the notice. Clause 10, Mr. Speaker, seeks to amend section 8, subsection 1A, to improve, and it seeks to improve the method of service of notice of possessory proceedings to owners and occupiers of adjoining land. And the applicant shall, not later than 21 days after filing the application for declaration of possessory title, cause a copy of such notice to be served to the owners of adjoining property. Just trying to skip some of it. The fees. Recommendation 9, Mr. Speaker, removal of that fixed fees for attorneys at law for the service. This bill, Mr. Speaker, recommends the removal of the fixed fee of $1,000 and recommends the setting of a ceiling of a maximum fee as opposed to just a fixed fee. All right, so it gives you the flexibility of variation of fees based on the scope of work, the amount of work to be so involved. The requirement for a deposit, recommendation that the applicant would pay a deposit for the administrative costs, including costs of making copies of the notices and so on and so on and so on. So all of those costs to be borne by the applicant. The deposit, Mr. Speaker, must accompany the application for clarity. So, Mr. Speaker, just to wrap up, just want to reiterate the 13 key changes. We've taken you some of the details that we believe is necessary. So just to summarize the key aspects of the bill. 1, it seeks to prevent a person from claiming possessory title to land more than once within a 20-year period. Secondly, it prevents a person from receiving possessory title for more than 1/4 of an acre of land, unless, of course, they can demonstrate that they demonstrate their adverse possession during the period. And thirdly, mandates that additional particulars be included in the application, which we discussed a little earlier. It also mandates the Attorney General to be a respondent in the matter. And it also mandates a report from the land surveyor. The bill also seeks to expand the responsibility of and medium through which the Registrar of the Supreme Court will publish notices. And it also mandates that an applicant serve the notice to the immediate owners who are in boundary with them. The bill also seeks to improve the method of service of notice, as we discussed earlier. It also removes the fixed fees, mandates that an applicant pay a deposit to cover those administrative costs, and remove the unique claim form and the form of entry of appearance under the Act, and replaces it with the Eastern Caribbean Civil Procedures Rule 2000. It empowers the court to set aside or vary the order granting possessory title after the allotment period has expired, except in exceptional circumstances. And finally, it corrects the certain references to the Registrar of the Supreme Court with reference to the Registrar of the Deeds and Lands Registry. Thank you, Mr. Speaker.
Thank you, Leader of Government Business. I now invite the MP for St. George Northeast to the floor.
Thank you, Mr. Speaker. Mr. Speaker, I will be brief, and I rise to join the colleague Leader of Government Business in support of these important amendments to the Principal Act and to strengthen the discussion as we go forward. I believe, Mr. Speaker, we are enhancing a reality that has existed in Grenada for generations now, where many of our people have lived on, they've worked and passed down land without the legal title to match their lived ownership. That's a problem I believe that the Possessory Titles Act of 2016 sought to resolve by giving some sort of legal recognition to those who, through 12 years of undisturbed and exclusive possession, own the right to claim the land. But, Mr. Speaker, over the last 10 years, we've had the opportunity to observe, and we see that major gaps are evident. And this amendment bill is about closing those gaps, strengthening the system, and protecting the integrity of land ownership in Grenada. A balance between justice for the occupier and protection for the right legal owner. Two very critical points, different, but they intertwine, because this is going to help strengthen the process in that regard. So I want to just touch briefly on three ways that this strengthening is taking place. One, by raising the standard. No more guesswork when it comes to land ownership. Mr. Speaker, people are stealing lands in local parlance through this legislation. This is a major gap because claims could be made at present on weak documentation and informal evidence. The bill that is before us seeks to change that, and it now requires a professional land surveyor report, detailed plans with measurements, boundaries, and adjoining owners, evidence of tax payments over time, and the identification of previous legal owners. This one is critical too because, Mr. Speaker, in speaking to some Canadians or engaging them, they indicate that they went abroad. They do own a piece of land. But somebody, whether a family member or friend, neighbor, decide to just squat on the property and live for the particular period that is prescribed in the Principal Act, and can then now apply for ownership of what they say is their land. This is wrong. So this is a major shift from the principle of assumption to a more evidence-based ownership of property under the possessory title. The second way, Mr. Speaker, is by strengthening the question of transparency. Mr. Speaker, the Principal Act, as I just mentioned, is a powerful one, right? It can transfer ownership without a traditional sale. And that is a problem, in my view, because here you have groups of people who, through legal means and their own expense in some instances, or through a loan, purchase property the right way. Then you have another group squatting, whether deliberate or in some instances circumstances, for a period of 12 years, and then under this current legislation could just own somebody else's property. That is unjust. So the process must be transparent and fair across the board, and this bill ensures now that we have mandatory service on previous owners, service on adjoining landowners, service on the Attorney General to protect state interests, and this one is critical too. I'll mention why shortly. And then, of course, the question of wider publication to newspapers, gazette, and digital platform. Mr. Speaker, so for the first time, as mentioned by the Leader of Government Business, the state, through the Attorney General's office, now has a formal role in verifying whether lands in this regard, under this legislation, is Crown lands. Because it's critical. I'll give you an example. We have a situation in Mardi Gras, for example, where an individual has attempted to claim Crown lands for his personal use. But as far as we know, now, that land is supposed to be state or Crown lands specifically allocated for a playing field for the people and the community of Mardi Gras. So, at this present situation, because of this gap, or these gaps, you have a situation where this particular instance is ongoing. And Mr. Speaker, what we are saying in these amendments is that we need to close these gaps and loopholes, because that is unjust and it is wrong. It should not happen. So, this is not just about reforming the legislation or enhancing it. In its simple form, it's about the question, too, of public protection when it is needed, particularly as it relates to what belongs to the state versus private landowners. And final way, Mr. Speaker, is by protecting the system against abuse. The Leader of Government Business spoke about people wanting to claim within short notice. So 1 year, you claim you own this piece of land here, next year, you want to claim you own another piece. That is something, Mr. Speaker, legislation, this amendment already seeks to rectify. So it now introduces a 20-year restriction on repeat applications. So you must wait 20 years or more to be able, or you must wait 20 years to be able to make a second application within that time span. The second one is that it limits 1/4 of acre unless properly justified. So you can't just come and say, you own this big estate here and it's private property, you've been living on it, and you're trying to claim for all of this because you want some stake. It has to be properly justified through now these upgraded amendments that's being proposed, and it, again, goes back to the question of evidence. And finally, there is a requirement for a financial commitment through deposits. The Leader of Government Business spoke to it, so I'm not going to go into the process, what it entails. So, Mr. Speaker, what we are saying is simple. The possessory title is a good bill, but it is not a shortcut to land acquisition, right? It is required to be structured, disciplined, and also provide a channel towards genuine land ownership. So you can't just get up in the morning again and say, you've been living on this property 12 years, and therefore you now want to claim, and you don't want to follow the proper channels. And the people who may be the rightful owners, and actually in some instances paying taxes, is in a sense defrauded out of their right and their just. So I just thought I wanted to add these few comments, Mr. Speaker, and believe that this is something that all of us should support. The intention of the Principal Act is a good one, but Mr. Speaker, there were loopholes, and this bill before us is attempting to correct them. Thank you very much.
Thank you, Honorable MP for St. George Northeast. MP for St. Mark.
Thank you very much, Mr. Speaker. Mr. Speaker, I rise to make my comments on the bill as presented by the Leader of Government Business. Mr. Speaker, as we are well aware, this is an amendment bill, which means that there's an existing bill already. I think it was in 2016. And today we're performing a duty which is supposed to be common to Parliament, that we amend legislations based on weaknesses or gaps that we would observe or detect over a period of time. And so I want to compliment some of the steps prescribed here, which I believe would sort of guide the process and protect where it needs to protect and to enhance where it needs to enhance. Mr. Speaker, I just have two comments. I'm going to make comments on two of the issues here. Clause 7, which seeks to insert something to the Principal Act, a requirement for the applicant to make a deposit of such sum as may be prescribed by the minister for the purpose of covering expenses for different processes, different procedures, whatever has to be done, whether it's to serve papers or persons in country, outside of country, etc. And sometimes it can be very costly. I would have preferred to see, and I think the public would like to get an idea of what the cost would be. I don't know, it probably could come in an SRO, but I think this will not be complete until persons do know what they're expected to pay, because sometimes one undertakes things and in the end it can come out in such a way that one realizes that you cannot, after making certain financial expenses, realize that you cannot go all, because I do know that some of these processes can become costly, and so the undertaker, person who's undertaking this process, should know ahead of time or get an idea what the range would be. And so similarly in clause 18, which repeals subsection 1 and 2 of section 34 of the Principal Act to remove the provisions relating to fixed fees for services by attorneys. I have no problem with what the attorneys make. My only concern is if someone does have a really true and truly legitimate claim to possessory title, then if you do not put a cap, if you do not put a ceiling, it could be a deterrent, a serious deterrent for persons who may have a legitimate claim. Some of the provisions here are very realistic, and I'm sure it's based on what would have happened over the years prior to the 2016 legislation as well as subsequently. We have seen persons who appear to make that their business, to occupy lands waiting for the 12 years, and then through a simple process, claim lands that really should not be theirs. And we have also seen persons lose their lands because of that, and because of ignorance. Because some people don't know about this 12-year story. So somebody might be staying on your land and say, you know, you're sorry for them, let them stay there. And before you know it, the 12 years come and you just hear the person is now the owner of the title of your property. So the steps taken to ensure that every interested party is served with documents, whether the person is in country and abroad, the step taken to ensure that the previous owner, prior to the 12 years of occupancy of this individual, is also served, so that if he or she does have a case, they can bring it. And so I applaud these steps. I just would like to see some real figures and some caps, some ceiling put, so that persons are not unnecessarily daunted by this bill. I welcome it, and I would just finally like to add that some more education. I think as a country, we have generally been weak in educating the public on issues that really concern them. And so I know this bill is going to be passed, but that should not prevent the government or any one of us from educating the public on how to protect their property in the first instance, how to access a property or a title in the second instance. But everybody concerned should be educated, should be informed, so that persons do not unnecessarily lose their property and that persons do not unnecessarily take properties. And I heard the member for St. George Northeast speak about something with Crown lands, and we have heard about other situations where lands for cemeteries or other things, in other words, the public property is being encroached on, either knowingly or unknowingly, and all of a sudden there is, after a certain amount of years, thank God the public side is 30 years, I hope they could bring it to 40, just so that we protect the lands of 50 years, protect the properties, because we are a finite country, we're very small, and the amount of lands we do have available is limited. And therefore, maybe at some other time, some other administration, or maybe the same one, who knows, could look at extending the time to protect the property of the public, the crown lands, so that our children and our great-grandchildren may have access to some lands for public use or maybe private use. It might be sold to some persons, but it is a concern when persons think that they can just jump and access lands because of loopholes in the law. So, Mr. Speaker, these are my comments, and I commend the changes made, and I hope that some of the comments I have made will receive some attention as well. I thank you, Mr. Speaker.
Thank you very much, MP for St. Mark, for your contribution. The Honourable Prime Minister.
Thank you, Mr. Speaker. I rise to support the bill and its passage in the House. I can say from a desktop research, which doesn't include a detail such as the possessory titles registry, if I may put it this way, the deeds and land registry, that hundreds of Grenadians have gained access to a possessory title since the passage of the 2016 Act. If you peruse the Gazette, for example, Mr. Speaker, just randomly, pick anyone in 2023, 2023, 2024, and since the Act is coming to effect, you may see 5 to 10 publications per Gazette of persons claiming or advertising their claim, seeking to have adjudication in the courts in relation to adverse possession claims. Now, I think the court itself has become quite stricter in granting or refusing to grant the titles in circumstances where obviously claims are contested, in circumstances where someone actually may have a proper, legitimate claim or interest in a land, but what they have is a defective title. And the court has clarified that adverse possession is not meant to perfect your title to land. And I explain by way of example that if your father owned land properly and he died without a will, for example, and left 3 children and a spouse, then the land will be, as a matter of inheritance law, owned by the spouse 50% and by the children 50%. If the spouse, for instance, wished to sell her interest in the land, she's required to get the consent of the other 3 owners. They would probably then be required, if they were actually doing a physical partition, to survey the land out, to agree on the portion that is the spouse, and then the 3 children are required to transfer their interests to the spouse. In many instances, what happens is that people simply do nothing. And over time, a child may then come and say, well, the land was my father's land. And he then wants to claim adverse possession against his brothers, his sisters, his mother, when in fact he already has title and some interest in the land and would have been on the land by virtue of the fact that he's a child of the parent who owned the land and lived there. And therefore there is nothing adverse because he would have been there as a virtue of license or permission of the family. And that the act is not meant to be used in those circumstances to try and help you perfect the title which you have, and all you need to do is do the appropriate administrative or legal work to do so. So the court itself, I think, has begun to recognize that the act was being abused in many instances and has sought to correct some of those instances. But we also recognize, Mr. Speaker, that there has been significant abuse by persons, especially when it comes to agricultural and large tracts of unoccupied lands, where clearly it is impossible to look at the land and say someone is in actual physical occupation of land. Short of a house, for example, being on the land, or clear evidence where you can literally go and see that the land is being farmed on a consistent basis, it's fenced, etc. A lot of the evidence that people have been using to say they're in possession of land has been, quite frankly, dubious. And even the common law recognizes things like grazing animals and so on land is not evidence of possession of land, because we know it is in Grenada. I mean, Kike would be a perfect example. You know, goat and sheep roam freely. And for you to come and say, well, my goat and sheep has been grazing on this piece of land, so I'm claiming adverse possession, obviously, is an abusive situation. So it is meant to tighten up and mitigate some of the excesses and abuses that have been coming, and also to not clog up the court system with dubious claims of adverse possession when persons have not in fact been there for 12 years, when they've not been in physical possession, and when their occupation has not been adverse. And this is important, because if you've given permission by the landowner to occupy the land, then really and truly your possession is not adverse to him. You didn't enter without his permission, you entered with his permission, and we want to make sure that we can bring some clarity to this. Having said that, Mr. Speaker, we do recognize that land is limited. We also have significant absentee ownership of land in Grenada. A lot of persons who own land don't reside in the country. They may never come back. Their children may never come back. And we also have to be able to give current and next generations of Grenadians the opportunity to be able to have proper title to land. In circumstances where you can't find owners, where they are not coming back to the country but are unwilling to sell, there has to be some limitations as to a situation where you don't end up where all the people living on the land don't own the land, and the people who own it are either uninterested or out of the country, or their generation following them are not interested and also out of the country. So we do also have to recognize that our migration patterns have contributed to, in many instances, large tracts of land being held in private ownership outside of the country. On many of the peninsulas you see, for example, on the east coast of St. David, they are owned by persons who don't reside in Grenada, who probably will never reside in Grenada, and simply are holding the land with a view of hoping one day that they will obviously realize significant windfall if they're able to sell it. But if, in the meantime, there is no access to proper land and to title ownership of land from regular persons who live on the island, we also have a challenge. So we have to be able to address this as well. The MP for St. Mark has left, but I should point out that adverse possession is not permitted against the Crown, and one cannot claim adverse possession against the Crown for the purposes of this Act, so Crown lands are protected. But having said that, we also recognize that there's a long history of squatting against Crown lands, and in some instances we've got to where there is no public harm to regularize and give people the opportunity to buy and purchase those lots, especially for housing, settlement, and dwellings, and so on. And so the land regularization program that the Ministry of Lands, led by the Honorable MP for St. Andrew Southwest, that land regularization is meant to address small land holdings where persons have squatted or given permission on an allotment to get them to actually pay for the land, get the title, and be able to move on. We have seen instances where persons have been given the allotments for 20, 30 years and refused to pay, at sometimes 50 cents a square foot. You know, and 20 and 25 years later, they simply come in and say, transfer it to my daughter, transfer it to my son, and they still want to pay 50 cents a square foot. Having occupied the land for 30 years free, having not paid and so on. So we also are trying to come to grips with this and to have an appropriate policy that if it's genuine, they can still transfer the land to their children, but at the same time ensure that they pay for it and pay for it in a short period of time rather than another 30 years. Again, or in which case then they will be getting land for free by not paying or honoring the obligation. So we expect, Mr. Speaker, that we'll have to constantly monitor the situation, and if ever there are abuses and so on that continue, that we will be able to address it. There are some structural challenges we face in Grenada, one of which is the absence of surveyors. I don't think we have enough surveyors that will actually make them. So it's a field where certainly we should be encouraging Grenadians to study, because there's a significant shortage of licensed land surveyors, and it is significantly impacting even the land regularization process. It actually impacts people's ability to buy and purchase and sell lands because you can't get surveyors. And it is something that we are trying to work towards encouraging more Grenadians to study surveying in all its forms, and so that we have a greater pool talent to be able to facilitate some of the land ownership issues that we need to address in the country. So I trust that all members of the House will support the passage of the bill. Thank you, Mr. Speaker.
Thank you very much, Honorable Prime Minister. Leader of Government Business.
Thank you, Mr. Speaker. Mr. Speaker, I wish to offer my appreciation to all members of the House who have contributed and offered their support to this bill. I want to thank them so much, and I now commit the bill to the House for further consideration.
Thank you, Leader of Government Business. Honourable members, the question is that bill be read a second time. All those in favour say aye. Those opposed say no. The ayes have it. I think the ayes have it.
A bill for an act shortly entitled Possessory Titles Amendment Bill 2026.
Leader of Government Business.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the House resolves itself with the Committee of the Whole House to enable this bill to be taken to consider this bill clause by clause. Thank you.
Honourable members, the question is that this Honourable House resolve itself into a Committee of the Whole House to consider the bill clause by clause. All those in favour say aye. Those opposed say no. The ayes have it. Indeed, the ayes have it. This Honourable House is now in committee.
Clause 2, Amendment of Section 2 of Principal Act.
Honourable members, the question is that Clause 2 forms part of the bill. Those in agreement say aye. Those opposed say no. The ayes have it. Indeed, the ayes have it.
Clause 3, Amendment of Section 3 of the Principal Act.
Honourable members, the question is that Clause 3 forms part of the bill. Those in agreement say aye. Those opposed say no. The ayes have it. Indeed, the ayes have it.
Clause 4, Amendment of Section 4 of the Principal Act.
Honourable members, the question is that Clause 4 forms. Leader of Government Business.
Thank you, Mr. Chairman. Mr. Chairman, I wish to propose an amendment to Clause 4 of the bill for the consideration of this committee. Clause 4A, subsection A, Roman numeral 2, and as well as Clause 9, if I might do that.
Go ahead.
Because there's basically the same change, Mr. Chairman. So Clause 9 and Clause 10A and any other clause in the bill is amended to delete the words East Caribbean Supreme Court Civil Procedure Rules 2000 And delete that and substitute it therefore with the words Eastern Caribbean Supreme Court Civil Procedure Rules Revised Edition 2023. So in all of those clauses and relevant section and subsection, where those words are seen, it will be substituted for the Eastern Caribbean Supreme Court Civil Procedure Rules Revised Edition 2023. Okay. All right. Thank you, Mr. Speaker. Mr. Chair.
Thank you, Leader of Government Business. Could you just, Madam Clerk, you got the change? Could you just read the change for the benefit of the House?
You see that one.
All right, Leader of Government Business, you made, do you have the recorded amendments you just put? She didn't capture everything.
Oh, okay, so you want me to report?
You just read it, the amended way, please.
Right. And I see, Mr. Speaker, also that the written version will be submitted to the House.
Okay,
Okay. So may I repeat now?
please.
Okay. Clause 4, subsection A, Roman numeral 2, clause 9, clause 10A, and any other clause in bill to be amended to delete the words Eastern Caribbean Supreme Court Civil Procedure Rule 2000 that is to be deleted and substituted therefore with the words Eastern Caribbean Supreme Court Procedure Rules, and you put in bracket revised edition, in bracket revised edition 2023, sorry, 2023. So that's it, Mr. Speaker.
Thank you.
Yeah.
Thank you, Leader of Government Business.
Thank you.
So, Madam Clerk, you may proceed.
Clause 5, amendment of
Just hold on, take it for the affirmation.
This is not working.
No, I'm seeking affirmation, right? The motion for the amendment is already before us. I just want the House to affirm the amendments to the bill. Because what we had before was the old bill now adjusted, right? So the Leader of Government Business has tabled an amendment to the bill. He has indicated that the copy will be circulated to the House, and he has actually read the revised or the amended bill for the benefit of the House. So I'm now going to ask the members to vote on the amendments just proposed by the Leader of Government Business.
Mr. Chair, just for clarity,
Yes.
the old rules, so we're moving from the rules 2000 to the revised edition
Yes.
of the rules 2023.
Yes.
Yeah, just for clarity.
Yes. Yes. All right. So even if you don't have the amendments before you now, it was presented to us by the government business, and we will have it. Actually, a soft copy, I assume, in short order. Right? So those in favor of the amendment, say aye. Those opposed, say no. The ayes have it. I think the ayes have it. So you may proceed.
Clause 5, amendment of Section 5 of Principal Act.
Honorable members, the question is that Clause 5 forms part of the bill. Those in favor say aye. Those opposed say no. The ayes have it. Indeed, the ayes have it.
Clause 6, amendment of Section 6 of Principal Act.
Honorable members, the question is that Clause 6 forms part of the bill. Those in favor say aye. Those opposed say no. The ayes have it. I think the ayes have it.
Clause 7, insertion of Section 6A to Principal Act.
Honorable members, the question is that Clause 7 forms part of the bill. All those in favor say aye. Those opposed say no. The ayes have it. Indeed, the ayes have it.
Clause 8, repeal and substitution of Section 7 of Principal Act.
Honorable members, the question is that Clause 8 forms part of the bill. All those in favor say aye. Those opposed say no. The ayes have it. Indeed, the ayes have it.
Clause 9, insertion of new Section 7A to Principal Act.
Honorable members, the question is that Clause 9 forms part of the bill.
Mr. Chair,
Do you have government business?
yes, Mr. Chair, thank you so kindly. Just for clarity and consistency, I'm just flagging that Clause 9 has been amended.
Yes.
So the amended version now is being approved.
Yes.
That's with the little change that I read
Yes,
earlier.
that's my point.
Right.
Because we won't have it before us yet.
Right. And the
Yes.
same will apply for Clause 10 as we go forward.
Correct.
Thank you kindly.
All right. Leader of His Majesty Opposition?
Yeah, Mr. Speaker, just a clarification. Well, actually, I was trying to get your attention since
Oh, sorry.
on 4. So I'm just curious to know, on the 9, if we go to, let me find it, Section 2, and that section refers to serving of the estate. Now, what if in a case where that person did not leave a will, probably there's no record of ownership? What happens in a case like that? What would this reference there look like in reality? So that was a question that I wanted to raise. And if you'll permit me, I'm just trying to find back the point. Right, and if you'll permit me, Mr. Speaker, since I tried very hard to get your attention, and it's clarification as well, that would be under Section 4, clarity on 4A, 5B, and that one has to do with taxes. Clarity as to what is the intent where, for example, the property is not in the person's name, there is no demand of the person to pay. How does that actually work out in a real case example? So just seeking some clarity on those two.
All right. Leader of Government Business, can you respond?
Thank you, Mr. Chair. I'm a bit tired today. So, I came to work a bit tired today, so I might not be as sharp. But the first one, I believe, we've referenced
in the event that the landowner, the original landowner died, what happens? Okay.
In the legislation and the bill, it speaks to the estate.
Yes. Yes. So, right. So it is saying that the notice must then be served on the estate, and therefore the administrator would then act on behalf of the deceased, but all conditions remain the same. Legal counsel? Am I right?
So there's no record.
Or if there's no, right, so in a case like that, there's no administrator, there's a next of kin. There should be a next of kin. In other words, notice has to be served. Notice would be served with those in boundary, notice would be served to the Attorney General chambers. And so when the matter is brought before the court will verify that the respective persons should have been notified, and that if it has been for a long period of time, it simply means that the person would not have been paying the taxes, or only if the current occupier is paying the taxes. Remember, according to the amendment, the occupier must present all those bills and receipts of taxes being paid. So,
and I just feel that legislation should not have so many questions, of doubts. So you say, for example, the person should have all the receipts, they should have evidence that they've been paying, but if a demand is not made in your name, the Inland Revenue did not send you something to pay tax on a piece of property for various reasons, how can you now present the receipts for it? So I'm just, in essence, asking if you think this is tight and clear enough in terms of how it's captured there.
we're open to suggestion for tightening up, but based on how the legislation is now enhanced, it is saying now that notice has to be served on the Attorney General. It has to be served with all those in boundary with. It has to be served on the landowner as well as the deceased, the person acting on behalf of the deceased. So all relevant persons, according to this, must be served notice, right? And then also the person must prove that they have been occupying the property. So it really, to me, it tightens it up from what it was before. It was a sort of easy walk through. So now this has added some clarity and some decisiveness in how we are to go about claiming possession of lands so occupied by someone over the period of time. So I think it sounds a bit tighter. But if you have a recommendation for tightening up any further, this is the time to let us know so we can tighten up a bit. Thanks.
I would imagine this would have been the person involved in the drafting, if she has any guidance as it relates to, or she's satisfied that it's that enough.
Well, this is committee. I believe she can speak in committee. She can?
No.
Okay, so let me see.
She may consult with you. Let me consult with us, but that's for the members.
Mr. Chair, may I proceed?
Right. You have government business.
Right. So, Council has informed that the proper thing to do is to serve on the estate because it would not be proper to preempt without evidence who that beneficiary will be, on whom we can serve notice. So the proper thing to do is to serve on the estate. And the legislation, the enhanced legislation now, or the bill, sorry, makes provision for all relevant parties to be served. So it sort of closes the gap that previously existed. So she's saying to us that she's not seen any further amendment that can be made in that particular section to add any more clarity, if I think I interpret her correctly.
All right. All right.
Mr. Speaker, I'll suggest we proceed until such time.
Okay, thank you, Leader of Government Business. Let's proceed.
Clause 10, amendment of Section 8 of Principal Act.
Honourable members, the question is that Clause 10 forms part of the bill. All those in favour say aye. Those opposed say no. The ayes have it, indeed, the ayes have it.
Clause 11, insertion of new Section 8A to Principal Act.
Honourable members, the question is that Clause 11 forms part of the bill. All those in favour say aye. Those opposed say no. The ayes have it, indeed, the ayes have it.
Clause 12, insertion of new Section 11A to Principal Act.
Honourable members, the question is that Clause 12 forms part of the bill. All those in favour say aye. Those opposed say no. The ayes have it, indeed, the ayes have it.
Clause 13, amendment of Section 12 of Principal Act.
Honourable members, the question is that Clause 13 forms part of the bill. All those in favour say aye. Those opposed say no. The ayes have it, indeed, the ayes have it.
Clause 14, amendment of Section 21 of Principal Act.
Honourable members, the question is that Clause 14 forms part of the bill. All those in favour say aye. Those opposed say no. The ayes have it, indeed, the ayes have it.
Clause 15, amendment of Section 29 of Principal Act.
Honourable members, the question is that Clause 15 forms part of the bill. All those in favour say aye. Those opposed say no. The ayes have it, indeed, the ayes have it.
Clause 16, amendment of Section 32 of Principal Act.
Honourable members, the question is that Clause 16 forms part of the bill. All those in favour say aye. Those opposed say no. The ayes have it, indeed, the ayes have it.
Clause 17, amendment of Section 33 of Principal Act.
Honourable members, the question is that Clause 17 forms part of the bill. Those in favour say aye. Those opposed say no. The ayes have it, indeed, the ayes have it.
Clause 18, amendment of Section 34 of Principal Act.
Honourable members, the question is that Clause 18 forms part of the bill. All in favour say aye. Those opposed say no. The ayes have it. Indeed, the ayes have it.
Clause 19, insertion of new Section 34A to Principal Act.
Honourable members, the question is that Clause 19 forms part of the bill. All those in favour say aye. Sorry, Leader of Government Business. Say again? I didn't hear you.
Mr. Chair, I stand down for
Okay.
making intervention at this
All
time.
right. Clerk, would just please repeat. Just go over your last Clause. Madam Clerk.
Clause 19, insertion of new section 34A to Principal Act.
Honourable members, the question is that clause 19 forms part of the bill. All those in favour say aye. Those opposed say no. The ayes have it, indeed, the ayes have it.
Clause 20, amendment of section of Schedule 1 to Principal Act.
Honourable members, the question is that clause 20 forms part of the bill. All those in favour say aye. Those opposed say no. The ayes have it, indeed, the ayes have it.
Clause 21, amendment of Schedule 2 to Principal Act.
Leader of Government Business.
Thank you, Mr. Speaker. Mr. Speaker, I wish to make an amendment to clause 21 of the bill.
Okay.
Recommendation for the amendment is to delete and substitute with the following new clause.
Okay.
Amendment to Schedule 2 to the Principal Act. Schedule 2 to the Principal Act is amended by deleting the following.
Go slowly enough so that the clerk can record it. Yeah.
Delete the following. Solicitors, apostrophe S, solicitors fees, sorry, thank you, for uncontested applications $1,000. So we deleting that. Solicitors fees for uncontested applications, $1,000 to be deleted. And substituting, therefore, the following new rule. Ready? Fees for services of attorney at law in uncontested applications not exceeding $7,500. Right. So that's the first. I have two changes, Mr. Speaker. So I want to pause here on this first change to await any interventions from the House. Thank you.
Members, I hope you heard the proposed changes by the Leader of Government Business. It's now open for input, debate, discussion. If it's okay with you, then we proceed to the next one.
Just to...
Leader of His Majesty Opposition.
Thank you, Mr. Speaker. Just to get clarity on what would have informed the change.
So we are removing the fixed solicitor's fee so that if the solicitor wants to charge $1, he can charge $1. He or she can charge $1. But in any event, the fee should not exceed $7,500. So we allow some flexibility there because every situation would be more complex than there are different levels of complexities in terms of resolving these types of property issues.
And, Mr. Speaker?
Yes, go ahead.
So I love your reference to $1, and it sort of amplifies the difference between 1,000 and 7,000 is quite high. A fixed amount of 1,000 now to a maximum at whose discretion, obviously, would be the person charging. So I was curious, why 7,000? Why not 2,000? Why not 5? If there was something that would have informed the 7,000 mark. Because it means it's now at the discretion of the individual, whether it's $1 or $7,000. And the previous comments by the member for St. Mark with regards to obviously the ability of some persons to be able to pay that upfront. I mean, I know you're smiling, but there are people in Grenada still who would find that very difficult. So I'm just asking if there was something in particular that would have caused you to land at the 7,000 mark.
Sure. Thank you.
Go ahead, Honorable Prime Minister.
Chair, the original proposed amendment was to remove the reference to the solicitor's fees for uncontested applications of $1,000 completely. On the urging of the Bar Association in particular, which indicated that the level of work that is required to facilitate even uncontested applications warrants far more professional time and therefore far greater fees. So the original amendment had proposed simply removing it. The Cabinet felt that simply removing it will mean that there is no, in fact, ceiling on what we could charge. And given that this was dealing specifically with uncontested applications, we felt that a ceiling should be put in place, and that the ceiling should be based on the fact that these matters do have to go to the High Court, as opposed to the Magistrates Court, which therefore involves, even for an uncontested application, some significant work. And therefore, on average, you probably would find that High Court matters, at a minimum, start somewhere in the region of $5,000 to $7,500. And so we wanted to have a cap on the amount that could be charged for uncontested applications, rather than simply removing the reference completely, in which case there would be no ceiling, and then attorneys at law would be free to literally charge anything they want. And because they're uncontested applications, not ones where other people are fighting, and so you have a lot more work to do, we felt that having a cap of 7.5 would recognize that it's High Court matters, but at the same time put a ceiling on what attorneys could recover for uncontested applications. So that's the thinking behind it, and why the figure of 7.5.
Thank you, Honorable Prime Minister. All right, so I think that takes us to the first one. Is that government business? You have another amendment?
Mr. Chair, I seek a brief leave to consult with the legal counsel.
Okay.
Thank you, Mr. Chairman. May I proceed?
Please do.
Mr. Chairman, I wish to propose the final amendment, this time to clause 14. And I am proposing, Mr. Chairman, the insertion of a new clause, clause 14. This new clause, Mr. Speaker, will cause a renumbering of all of the other clauses. This will be clause 14. So what was then clause 14 will become clause 15, and the others will take a domino effect accordingly in terms of renumbering.
All right, so we'd have 22 clauses.
Yes, Mr. Speaker.
Okay.
And Mr. Speaker, my change are as follows, and it is very similar to the very first intervention that I made relative to clause 4, 9, and 10. And it reads as follows. Amendment to Section 19 of the Principal Act.
Honorable Member, you have to go slowly. Eh? We are putting in a new clause for 14.
Yes.
Which means she must get it, the clerk, because we have to go and take the vote on it.
Right.
It's a new clause now.
Yes, so I'm not going any faster than this.
Okay, go ahead.
Amendment of Section 19 of the Principal Bill okay, of the Principal Act. Section 19. So that's a new so that was the heading I gave you, right? So 14, Section 19. Of the Principal Act is amended by deleting the words and in inverted commas, I'll just read it fast and then slow. Eastern Caribbean Supreme Court Civil Procedure Rules 2000. Eastern Caribbean Supreme Court Civil Procedure Rules 2000. Close inverted commas. Before the comma, and substituting therefore, the words open inverted commas, Eastern Caribbean Supreme Court Civil Procedure Rules in bracket revised edition 2023 close inverted comma. All right, yeah, and that's it. Thank you, Mr. Chairman.
All right, this is the second amendment as tabled by the Leader of Government Business. It's now open to the floor for comments, if any. Okay, so I now put those amendments to the vote. We have listened to the amendments as proposed by the Leader of Government Business. And now I would like to put it to the vote. Those in favor of the proposed amendments by the Leader of Government Business, say aye. Those opposed, say no. The ayes have it. Indeed, the ayes have it. So the amendment have been approved by the committee. Let's now go back to the 14th. 14 is a new insertion, so we have to go back to it. Yeah, I think he had a new one. So we need to go back to it, read it, so the members can vote on it. And then we go to is it the last? Or? I think we did 21. So let's go back to 14 and then do 21 and close. Yeah?
Mr. Chairman, respectfully,
Yes.
we did that already.
We did which one?
21 already.
Well, I couldn't recall. That's why I said I didn't remember we did 21. We did it. All right, but let's just take the vote on the new one that you put in.
Yes.
Yeah. Okay. So we did 21 before. Yeah, 14 is a new one.
Clause 14.
It's amendment to.
Clause 14, amendment of section 19, amendment to section 19 of the Principal Act.
Honourable members, the question is that clause 14, the new clause 14, forms part of the bill. All in favor say aye. Those opposed say no. The ayes have it. Indeed, the ayes have it.
Clause 1, short title.
Honourable members, the question is that clause 1 forms part of the bill. All those in favor say aye. Those opposed say no. The ayes have it. Indeed, the ayes have it. Leader of Government Business.
Thank you, Mr. Chairman. I beg to move that the House resumes and that the Chairman report progress on the bill.
Honourable members, the question is that the House now resumes and the Chairman of the committee reports progress on the bill. Those in favor say aye. Those opposed say no. This Honourable House now resumes. Honourable members, I have to report that the bill was considered by a committee of the whole House and passed with amendments. Leader of Government Business.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the Chairman's report be adopted.
Honourable members, the question is that the Chairman's report be adopted. Those in favor say aye. Those opposed say no. The ayes have it. Indeed, the ayes have it. Leader of Government Business.
Thank you, Mr. Speaker. I beg to move the third reading of the bill.
Honourable members, the question is that the bill be read a third time. Honourable members, the question is that the bill be read a third time and pass. All those in favor say aye. Those opposed say no. The ayes have it. Indeed, the ayes have it.
A bill for an act shortly entitled Possessory Titles Amendment Bill 2026.
Item 16, request for leave to move the adjournment of the House on matters of urgent public importance.
Leader of Government Business.
Thank you, Mr. Speaker. I beg to move that this honorable House be adjourned sine die, and to inform that we will be proceeding immediately upstairs where we usually have lunch and for the presentation by the protocollaris as well as the statutorization transition team. We will, Mr. Speaker, be having a working lunch. We hope we can wrap up all of this by 1 p.m. today. Thank you.
All right, so thank you, Leader of Government Business. Clearly, we have some members who would like to speak on the adjournment. I noticed that of Honorable MP for St. John and the Honorable MP for St. Andrew Northeast. So I invite the Honorable MP for St. John to take the floor.
Thank you, Mr. Speaker. Can I get there? Thank you so much, Mr. Speaker. Mr. Speaker, I rise on the adjournment to address a matter that was raised on the previous agenda item on the personal explanation in which the honorable member, for the constituency of St. George Northwest raised some controversial issues in relation to the fire at the Perseverance landfill area. So around this context, Mr. Speaker, I know we cannot debate it, but I would want to present to this honorable House the facts of what transpired and what continues to happen with the stellar support and management of the authority so that Hansard can accurately report and record what has transpired. So, Mr. Speaker, let me say at the outset that I fully appreciate the concerns that any fire at or near a waste disposal facility can generate among the public. Concerns about public health, environmental safety, and the well-being of nearby communities are legitimate concerns, and so I'm happy that it was raised in that context if it was a genuine concern. They deserve, Mr. Speaker, sober treatment grounded on facts, not speculations, in evidence, not assumptions. So it is precisely for that reason that I must respond, because what was suggested this morning, directly or indirectly, Mr. Speaker, was not merely that a fire occurred. What was suggested was that the Solid Waste Management Authority was itself responsible for causing that fire, and that is a serious assertion. It is also at this stage unsupported by any conformed investigations of the same. So, Mr. Speaker, I would just briefly go through the official situations report submitted to my office, which establishes that an extensive surface fire emerged in the early mornings of March 8, 2026 in the southeastern area of the Perseverance disposal facility, specifically in the area used as a store for construction and demolition waste. We call it C&D waste, used tires and bulky items. The report, Mr. Speaker, also made clear that the fire was not on the active landfill side or the site, but on the C&D and tire storage site. It further notes that the fire was first detected by security personnel at around 12:08 a.m. on March 8th, and that the cause of the fire was at the time unknown, with investigations ongoing by the RGPF. So let us be very clear in this honorable House, Mr. Speaker, there is at this time no confirmed finding that Solid Waste, the Management Authority of Solid Waste, started this fire, none. What there is, however, is evidence of response. The report confirms that the authority staff responded promptly after the alert was raised, that the fire service of the RGPF joined the response, and that measures were put in place to contain the fire to the tire storage and the C&D area and to protect the active municipal waste disposal site from spread. The use of pumps, Mr. Speaker, hoses, fire tenders, heavy equipment, and separation corridors all form part of the response effort. And based on the latest preliminary notes now provided to me by the General Manager, I am advised that the site is currently contained and under monitoring. So the statement that was made in terms of there is a big fire happening today is not accurate at all. I am further advised, Mr. Speaker, that the fire service was satisfied that the authority's containment actions had restricted the fire and that containment and response measures remain in place. Mr. Speaker, this is not institutional recklessness, that is institutional response by the authority. I am also advised, Mr. Speaker, that there was a reoccurrence on the night of March 20th, 2026 at the same CND site. Again, the matter of source remains one for technical and investigative determination, and it would be inappropriate for this House to make conclusive pronouncements ahead of that process. But I am advised that the March 20th fire, Mr. Speaker, is being treated differently in character from the earlier surface event, with indications of subsurface combustion and likely spontaneous ignition dynamics associated with materials present on site. That distinction matters, Mr. Speaker. It matters because it underscores the complexity of fire events at waste storage areas and the irresponsibility of reducing them to simplistic political claims. Mr. Speaker, in relation to public health and surrounding communities, the official report notes that the prevailing wind direction has generally pushed smoke offshore and seaward, thereby reducing prolonged landward exposure, though it is also cautious that during early morning atmospheric inversions or stagnation periods, smoke may temporarily affect nearby communities. The preliminary technical advice now before me indicates that the risk to communities has been regarded as relatively low, but we are not distinguishing or paying a blind eye to the fact that there are persons that might have respiratory problems such as asthma and the likes, young babies, elderly persons in the communities, and can be affected, and that the Ministry of Health's epidemiological unit, Mr. Speaker, I always have a tongue twister with that word, has not communicated any anomaly in relation to pertinent health conditions among surrounding residents. That does not mean, of course, as I mentioned, that we dismiss the concerns. It means that we respond proportionately. We ensure that we have inter-ministerial and intergovernmental approach towards addressing the public health concerns through the support of the Ministry of Health and on the basis of evidence. And we are urging and imploring persons in the area as well, Mr. Speaker, if possible, to wear a mask whenever there is an ignition, again, or there is any smoke that is unbearable or can cause any sort of public health concerns, to wear a mask, stay indoors, try not to open your windows unnecessarily, your doors unnecessarily, and to ensure that you stay away from the zone in which the fire occurred. Mr. Speaker, the report also reveals a difficult but necessary truth. There remains persons occupying or residing on or near sections of the affected site, including areas exposed to noxious fumes and heat, despite instructions from fire officers as well as the managers on site from the authority. The official report, Mr. Speaker, had already raised concerns about the need to remove persons residing on the burning site, both for their own safety and to allow the authority full control of the area. This, Mr. Speaker, is not a minor issue. It is a governance issue, a safety issue, and indeed a political issue requiring coordinated state action, Mr. Speaker, because no waste authority, however competent, can fully secure, Mr. Speaker, and manage a disposal or storage site if unlawful occupation, unauthorized access, and repeated breaches of operational control continue unchecked. And we know where these concerns and where these issues stem from. Clearly, it was not within our tenure from 2022. Mr. Speaker, if we are to have an honest conversation about the issue, then let us have honest conversation, and then show that we can give solutions as opposed to trying to score cheap political points in the Honorable House. For many years, Mr. Speaker, the country lived with recurring fires, let's not forget, chronic odor, poor waste segregation, open accumulation, and long-standing public frustrations associated with the dump site perseverance. There were repeated complaints from citizens, Mr. Speaker, about the smell, about the smoke back then, the disorder, and the seeming absence of a strategic solution. This did not begin in 2026, Mr. Speaker. It did not begin in 2022. These are structural problems that accumulated over time, and so public health and all of the lights that were mentioned were also there back then when nothing was being done. The difference, Mr. Speaker, and I note that for adjournment there might be a time frame attached, but I am begging now, Mr. Speaker, for additional 5 more minutes to that allotted time, so that I may run through the facts of that and conclude on that. So the difference, Mr. Speaker, is that under this administration and under the strengthened leadership direction given to the Solid Waste Authority, we have not accepted that old reality as normal, and we continue to work in terms of strengthening our managing capabilities and operational standards. We have been working, Mr. Speaker, to move waste management in Grenada from dump and burn paradigm towards a more modern, planned, and circular model of environmental management. This is not rhetoric, that is a record, Mr. Speaker. The material before me shows that substantial progress has been made in recent years, Mr. Speaker. The authority has moved to establish and commission recycling infrastructure at the Queen's Park Recycling Facility, including an industrial baler, a glass pulverizer, if that's the right terminology that they call it, and plastic shredders, with the support of partners, both regional as well as international, Mr. Speaker. It has also expanded national recycling collaborations, including the private sector as well. Under the Recycle Organics Program, Mr. Speaker, and related initiatives, Grenada has completed waste categorization work confirming that a significant share of municipal solid waste is organic. It has expanded home composting to households across multiple communities. It has rolled out school composting initiatives, and it has launched a composting pilot at Perseverance. These are not symbolic acts, Mr. Speaker. They are systemic building blocks for reducing landfill pressure and changing how waste is handled nationally, not when it gets to the landfill, Mr. Speaker, but right in our homes, right in our communities, so that we can lessen the burden of having to find more cells or more sites for waste disposal. The same document, Mr. Speaker, speaks to broader strategic plans, a national composting and waste separation program, upgrades for waste systems in Carriacou and Petit Martinique under the World Bank's Blue Economy support, and a pending cabinet-approved engagement around the Halifax Bay Eco-Village concept, including a waste-to-energy, solar, sludge treatment, and safer transfer systems. So this is what serious reform looks like, Mr. Speaker. So when some seek in a single breath to imply that the authority is both responsible or the villain of the day and somehow devoid of progress, I reject that framing, Mr. Speaker, by ensuring that we place facts on the table in terms of what we are doing to ensure that these chemicals that are present at the landfill does not reignite any fires, that we have control over this site in terms of bringing a form of social order to the persons that are residing around the area, and as well as to ensure that we have futuristic planning for a circular economy model. Mr. Speaker, the authority today is widely regarded, including regionally as well as internationally, as operating one of the better or best managed disposal systems in the OECS space. That did not happen by accident, Mr. Speaker. It happened because of leadership, because of policy focus, investment, institutional strengthening, and the relentless work of the technical and operational staff who often labor under very difficult conditions, Mr. Speaker. They go overtime and beyond. And so I want to commend the General Manager and his team at the authorities for a tremendous job that they have been doing over the last 4 years. Mr. Speaker, this does not mean the system is perfect. It is not. We still have serious issues and challenges in terms of the stockpile tires that we have, the C&D waste management, unauthorized access by persons who are even trying to go there themselves and salvage things from the fire, fire risk as well because of the chemicals, financing constraints, enforcement gaps, and the need for accelerated modernization. But the responsible conclusion to draw, Mr. Speaker, is that it's not that the institution should be casually commended, but the responsible conclusion is that the institution must be further strengthened, and that is precisely the path this government has took when we got into office and continues to take as we govern this country. The fire itself also illustrates something broader, Mr. Speaker. Waste management is not merely a sanitation issue. It is a public health issue. It is a land use issue, and we have the partner for Sustainable Land Management, PISLM, the Partnership Initiative, that is working along with us in terms of a land use policy, and that is going to incorporate all of that as well. It is also, Mr. Speaker, a climate issue. It is an enforcement issue. It is also a development issue. If we fail to reduce waste volumes, if we fail to separate waste streams, Mr. Speaker, if we fail to remove hazardous accumulations and modernize disposal systems, then we pay later in fires, in smoke, in contamination, higher cost, and public anxiety. So that is why this government has treated waste management reform not as an afterthought, but as part of the larger environmental modernization agenda of this state. So, Mr. Speaker, I therefore wish to place all of these that I've mentioned here on the record, that one, and I will reiterate, the fire in question was on the C&D and tire storage site and not on the active landfall. Second, that the cause of the fire remains unconfirmed and investigations remain outstanding. Third, that the authority and the fire service mounted an active response and containment effort, and the site is currently contained and under monitoring. Fourth, there has been no reported forest encroachment, and the public health risk to surrounding communities appears on the basis of current technical advice to be relatively low, though continued vigilance remains necessary both on the part of the managers as well as the community residents. Fifth, this incident underscores the need for stronger site control, stronger enforcement, improved material handling, and accelerated reform, all of which this administration has already been advancing. And finally, Mr. Speaker, this House must be careful. We must be careful not to convert legitimate public concerns into careless accusations. We must be careful not to undermine confidence in public institutions through statements that go beyond the evidence. And we must be especially careful, Mr. Speaker, in a matter involving health and safety, not to inflame public fear without technical basis. The people of Grenada deserve better than heat without light, Mr. Speaker. They deserve facts, they deserve responsible leadership, they deserve institutions that are allowed to do their work, and where necessary are strengthened to do it better. So this government, through my leadership, Mr. Speaker, as Minister for Environment, will continue to provide that leadership. Thank you.
Thank you, MP for St. John, MP for St. Andrew Northeast.
Thank you, Mr. Speaker. Mr. Speaker, I rise at this time, and it's obvious you can see that I'm wearing a simple t-shirt, Mr. Speaker. And while this t-shirt may appear simple, it carries a very heavy message, because it bears the image and memories of our late Tereshal Sebastian, who lost her life as a result of gender-based violence, Mr. Speaker. And we must remember that her story must not just fade away into silence. And as we remember her today, we also stand in solidarity with every woman, every girl, every person who have endured this painful reality of gender-based violence. Mr. Speaker, many of us, we have marched the streets. We have advocated against gender-based violence. However, we must accept the reality that the changes that is necessary will not happen in the streets. The changes necessary, Mr. Speaker, must happen right here in this Parliament. And so, we must ensure that when we are bringing laws or bringing the bills to pass into laws, Mr. Speaker, we must never forget the Gender-Based Violence Act that will protect our victims, that will ensure that we end this scourge of violence in any form, once and for all, and to send a strong message that violence in any form is not tolerated in our Grenadian society. So, Mr. Speaker, we must never continue to respond to these tragedies. We must be more proactive. It is very important that we be more proactive, and I believe that whatever bills we bring here to enhance should send a strong message that we would not be reacting any longer, but we are seeking to eradicate gender-based violence once and for all. So, Mr. Speaker, our greatest tribute to Terry Shell Sebastian, who would be laid to rest today, and following this session I'll be heading up to the funeral, Mr. Speaker. The greatest tribute is for Parliament to ensure that we bring the bills that would create the change to end the scourge of gender-based violence. So may her memory move us to make those decisions, and may her soul rest in peace. Thank you, Mr. Speaker.
Thank you, Honorable MP for Senator Northeast. The Leader of His Majesty Opposition, please take the floor.
Thank you, Mr. Speaker. Mr. Speaker, I rise this afternoon in my capacity as leader of the Public Accounts Committee, but I have to make a statement of serious concern because we are on a trajectory that is very frightening. The member for St. George Northwest referenced this morning that we continue to call sittings with absolutely no consultation with this side of the House, which happens to be an equal side, for what that is worth. But, Mr. Speaker, I listened to the Leader of Government's Business on his announcement of the session this afternoon. And I'm troubled, actually troubled, by the way we are doing business in this honorable House. So, the opposition got an invitation to attend a presentation on Project Polaris at 3 p.m. this afternoon. While I honestly, and this is my honest view here, while I honestly find this to be disrespectful, we have taken a position that will be represented at this session. And disrespectful, Mr. Speaker, because at this point, and the word inside presentation, I heard the word consultation, I'm not even sure what it is right now. But I'm saying after all has been said and done, the opposition is asked to attend today a presentation on Project Polaris. But let's put that aside. Mr. Speaker, the member stood up, and we're sitting right here. The member stood up and said, we will be having a working lunch. This is unacceptable. Who's we? Who is we? You cannot sit on the other side and dictate to this side, like we are your children. So there will be sitting today, there will not be sitting tomorrow. We will be having a presentation at 3. No, we are having a working lunch immediately after this. This is unacceptable. And to continue to accept this kind of behavior is sending the wrong message that this House, Mr. Speaker, comprises two sides of elected members from 15 constituencies. And so, Mr. Speaker, I'm saying this for what it's worth today. And I'm appealing to the members on the other side. We are not your children that you summon to sessions at your will and your pleasure. If the government wishes to make a presentation that it would like the opposition to be part of, we appreciate the invitation. If you've made a change to the schedule, if you decide you are changing the format of the session, then the courteous thing to do is to inform us, engage us. Are you available to do a lunch presentation or work? And what is working lunch? Am I prepared for a working lunch? I don't know. So I'm just making this point, Mr. Speaker, for what it's worth. I'm becoming extremely tired of the way that we are doing business in this House. And I want the record to reflect this. But substantive, Mr. Speaker, I want to use the opportunity to bring the House up to date on some matters relating to the Public Accounts Committee. I believe we are all aware, as we've made the decision in this House, that the Public Accounts Committee comprises 5 members, 3 members from this House and 2 members from the Senate, Senator Salim Rahman and Senator Roderick St. Clair. Mr. Speaker, as contained in Section 69 of the Standing Orders, the mandate is given to the Public Accounts Committee to carry out certain functions. Mr. Speaker, whether it is to ensure that there's value for money, scrutinizing of government's record, whatever it is, Mr. Speaker, is contained within 69 of the Standing Orders. Whether it is summoning of officers within the public service, within statutory bodies to give account for their spending, etc., it all falls within the ambit. The requests for reports and records are also contained in there. So just to say to this House, Mr. Speaker, that this committee has been functioning, meeting regularly to discuss the business that we've been assigned to do. And we had the opportunity, and I don't think the House was officially informed since then, we had the opportunity to attend a very intensive training in London some time ago, where every member of the committee was given that opportunity to participate. The 2 members from the Senate and the 3 members from this House. Mr. Speaker, in addition to that, we invited members of statutory bodies, directors and management, as well as permanent secretaries, because we felt in launching out into the deep in regards to this work, it is important to sensitize key stakeholders. So we did. The participation was satisfactory, and in addition to that, we believe that participants left there very much informed as to what the expectations are. And I want to commend those who participated and made these sessions what I consider to be very successful. Mr. Speaker, we're at the stage now where we are about to begin to review public records, and members of the committee have already started to review the list of records to determine where the priority would be placed as it relates to those records. We've engaged members of the leadership of the public service, inclusive of the Director of Audit, the Accountant General. We can probably include there permanent secretaries as it relates to the processes, the procedures, and I think we've done all that we should do as it relates to sensitization, as it relates to laying the foundation for the work that is ahead. Mr. Speaker, in addition to that, I want to notify this House that yesterday at our last meeting, members of the committee raised concerns as it relates to one of the matters in public domain as it relates to the Grenada National Lottery Authority. And in the context that some time ago, we had a Minister of Government indicating that there is a high level of corruption within that organization, a Minister of Government specifying that he would have written to the head of the board of the National Lottery Authority, and to the extent of dismissal because of activities that this individual was involved in. We don't know, I don't know. This is what the minister, the line minister, would have stated. Subsequently, Mr. Speaker, we were told that this particular individual was recalled, and of course we know subsequently it's public information that the minister in question was fired from the cabinet. Mr. Speaker, the committee's decision, which I want to inform the entire House this afternoon, the decision is to ask the Accountant General, the Director of Audit, Mr. Speaker, to conduct an investigation into the National Lotteries Authority and to provide that report to the Parliament of Grenada. So I wish to inform you, Mr. Speaker, and the entire House of that decision of the Public Accounts Committee. And I want to express appreciation to all members for their cooperation and support to the work that has started. Thank you, Mr. Speaker.
Thank you to Leader of His Ministerial Opposition. All right, I see no other lights. The request for the adjournment has been put forward by Leader of Government Business. I now put to the vote. All those in favor, say aye. Those opposed, say no. The ayes have it. Indeed, the ayes have it. Honorable members, this Honorable House stands adjourned. Sign it aye.